Welcome to Light Over Heat with Professor David Imani. Today I'm excited to present to you a conversation I had with the authors of this book, To Trust the People with Arms, the Supreme Court and the Second Amendment. Bob Cottrol is a professor of law, history, and sociology at George Washington University, and Brannon Denning is a professor of law at Samford University. Please enjoy this conversation and let me know what you think. Well, thanks both of you so much for joining me. I'm really excited to talk a little bit about your new book. Can't claim that I've read every single word, but I read as many words as I could. And so, let me begin with a sort of, I think it's a double-barreled question, and maybe one of you can take one and one of you could take the other. But really just sort of how did the book come to be? What was the impetus for, writing the book? And I think the part of the reason I asked that question is that a lot has been written about the history of the Second Amendment. And so I wonder, what the unique contribution of the book is. So the double-barreled question is kind of the impetus for writing the book and what its unique contribution is relative to the other things that have been written about the history of the Second Amendment.
Well, I think that what started us looking at doing this book is we had written before, each of us individually, on the issue of the Second Amendment and what was its original meaning and the original understanding behind it. Um, but then we had done this long before Heller and McDonald, the two cases that basically established the Second Amendment as an individual right that binds both the federal government and the state governments. So we've done this, but then we looked at the fact that Heller and McDonald were actually decided, and it's one of the great stories, I think, in the legal history of the United States. That is, you have an amendment that during its adoption in the late 18th century, 1791, when it's formally adopted into the Constitution, there's universal acceptance of the Second Amendment and the idea that the citizen should be armed both for the defense of himself, but also the defense of the community as well. And that has universal support, but it begins to fall apart. The support for it begins to fall apart, particularly after the Second World War, and especially in the 1960s. The turmoil of the 1960s leads to a gun control movement that is frankly prohibitionist. We are out to ban as much of private gun ownership as we possibly can. And it's an idea that gets taken over by the press, by most intellectuals and members of university communities who comment on the subject. The idea is that the Second Amendment really doesn't protect anything, despite its language, saying that the right of the people to keep and bear arms shall not be infringed. The predominant view in universities and among journalists and others who are opinion makers is that the Second Amendment really, again, despite its language, doesn't actually provide any real protection for the citizen. And it enters a period of dismissal by many of the people who shape our public opinion, and also the people who kind of shape the opinion of the courts. And part of our story is how that thinking gets to be reversed, and how the original view that the Second Amendment was meant to protect the right of the individual and not simply a state militia of some sort, some undefined sort, I might add, that view gains traction, and how that view gains traction and ultimately leads to both the decision in Heller saying the Second Amendment is in fact an individual right, and also the decision in McDonald that it applies to the states as well as the federal government. And that also involves a revolution in constitutional thinking um, in two ways. One, with respect to re-examining the Second Amendment and the idea that it protects the right of individuals, but also re-examining the 14th Amendment and a final recognition that the 14th Amendment was meant to apply the Bill of Rights to the states. Now, I don't want to get too far into constitutional theory and history here.
Well, I also want to put a couple pins in those because those are some moments I want to come back to. So for
Oh,
sure.
okay. Okay. But let's say that that had been a point of controversy, even though, again, if you look at the history of the 14th Amendment, it is clear that those who drafted the 14th Amendment intended to make the Bill of Rights binding on the states. It had not been before the Civil War, but that was the intention after the Civil War, but that was thwarted. So ours is really a story of constitutional comeback, both of the Second Amendment and the 14th Amendment. And I think that's one of the more exciting stories in American constitutional history. And
Yeah.
so I think we managed to bring it together within the pages of the book.
Yeah, and if I could just piggyback on some of Bob's comments, I think that it's one of the things that I think people may not appreciate is that the gun control movement was ideologically cross-cutting. Uh, Lights just went out here. Ideologically cross-cutting. I mean, California's strict gun laws were signed into law by Ronald Reagan. There were many conservative elites that supported gun control, and so one of the stories is that gun control had elite support, but it lacked public support because where it was put on the ballot in Massachusetts and California, voters went into the voting booth and voted it down. And so I think, by contrast, the gun rights movement succeeded because popular support ended up attracting elite support when legal academics began to publish articles about the Second Amendment in elite law reviews. Our friend Don Cates, the late Don Cates, published an article in 1982 in the Michigan Law Review, and then Sandy Levinson, who teaches at Texas, published an article in 1989 in the Yale Law Review, and suddenly it became a respectable avenue for academics to pursue. So I think one of the stories is that successful social movements need both elite and popular support in order to succeed.
Yeah. Yeah.
Also, I was going to say another aspect that we look at, and that I think is very important, is you have to not only look at what's occurring in the academy in terms of academics writing articles, but also about the national culture as such. One thing that in many ways sustained the culture of arms and the armed citizen, and the idea that the armed citizen was critical to the survival of a free state, was, interestingly enough, World War II. And I think often social and cultural historians don't look at war and the cultural and social impact that it has. If you think of the Second World War, it's probably one of the largest social and cultural events that occur in the 20th century. Of men who are between the ages of 18 and 40 during that time period, roughly half go into the armed forces. That's one of the most major sociological events of the 20th century. And these individuals have the personal experience of fighting tyranny themselves, seeing the value of a population familiar with arms, standing against tyrannical governments. And one of the things that's interesting about the World War II generation is when they come home, they have easy access to the military weapons that they used during the Second World War. And I think that's a profound cultural moment in the nation's history, and it affects thinking about arms and the citizens, and has I would argue, a profound effect along those lines.
Yeah, no, that's a great point, and I think one that doesn't get made often enough in terms of understanding the particular inflection that gun culture takes in that post-war period. And both of you have sort of mentioned the gun control movement, and I kind of want to move us in. The book unfolds chronologically, so I'll have a couple moments along the way, and I definitely want to finish with your comments in the epilogue because those were some of the most interesting for me to think about as someone who's kind of involved in these debates. But the book does unfold chronologically, and I note that the title is "To Trust the People with Arms." I've read enough of the book to know where that comes from, but tell the people who are watching who maybe that doesn't immediately resonate with them where that's from and why you chose that as the title, because I think it's it's loaded, so to speak.
Well, that's from James Madison, who's the author of the Constitution, the Bill of Rights, and particularly the Second Amendment. And he writes this in Federalist 46 before the Second Amendment is drafted. The Federalist Papers are designed basically to sell the Constitution. The Federalists are those who say, look, the Articles of Confederation simply aren't working. We have a government that is totally dysfunctional, and we won't even be able to defend ourselves should the need occur, as we had real trouble during the Revolution. So we need a constitution that creates a national government, something more than a loose confederation. One of the things that people are afraid of is, will this new government infringe on long held rights of the American people, including the right to bear arms? And Madison wants to assuage them by saying, uh, look, we're different from the other nations, the European nations that we're familiar with, because part of our government, part of our culture is this idea of trusting the people with arms. That we're unlike the governments of Europe, which are afraid to trust their people with arms. We trust the people with arms. And then Madison, after writing Federalist 46 and other parts of what are called the Federalist Papers, then proceeds to draft a Bill of Rights, the first 10 amendments, which is to sort of seal the idea that the new Constitution is not going to infringe on long-held rights. So the person who writes the provision discussing the right of the people to keep and bear arms had previously stressed the importance of trusting the people with arms.
Yeah. And Brandon, I mean, to me, I think that that comparison between Europe and the new American nation that Madison is drawing at the time seems to be the same today, right? The United States differs quite a bit from these other European countries.
Yeah, I think if nothing else, the Second Amendment represents a sort of ideological commitment that stands in opposition to, Max Weber, sort of famously said that a legitimate state is one that has a monopoly on the instruments of violence, and the Second Amendment is a rebuke to that worldview and that ideology. And I think there's really something that is in our political DNA. There's a great essay that Gordon Wood published in the early '80s where he sort of made the argument that the framers were just a little bit paranoid and sort of thought the worst. And I think they were prepared for a situation in which all bets were off, and it was every man for himself. And the Second Amendment sort of reflects that. And it's something that's tricky because it can sound paranoid and all that, but the framers sort of took for granted that you had a duty to engage in individual self-defense, and the Second Amendment encompasses both the individual right to self-defense and then self-defense writ large, self-defense of the body politic, which in sort of that era's political theory was taken quite literally.
Yeah. And you do address the issue of the role of the militia, the understanding of the militia, how the language of the Second Amendment gets so convoluted relative to a previous version that was proposed. And the one thing that always struck me is I'm not this is not my field, obviously, so I read this more as a kind of layperson, but the idea that uh, the individual right was sort of subordinate to this militia clause that so many people cling to seems out of step with even some of the language that appeared in state constitutional right to keep and bear arms language at the time. So it's not like even if you adhere to the sort of militia idea, how do you reconcile that with the popularity of the idea that there is an individual right as represented, for example, in some state constitutions?
Well, I think some of the advocates of the militia only theory, um, will, for them, no combination of words, no language will confer an individual right. I was reading yesterday for a class a brief of a group of historians who were arguing that the Second Amendment was only meant to protect a militia right. Um, and they also said that about the Pennsylvania Constitution, which has an analogous provision. And that Constitution said that the people have the right to keep and bear arms for defense of themselves and the state. And they were trying to argue, well, this was only for the militia. Well, what does themselves mean within that
Mhm.
context? It essentially means that no matter what the language says, they're going to read something other than the plain meaning, which is the right of individuals, the right of the people. The right of the people to keep and bear arms is not the right of the state to organize a militia.
Yeah. Yeah.
Well, and also I think it often gets overlooked, and I think Bob alluded to this earlier that whatever the framers in 1791 thought that they were doing, uh, by and I think that I Bob and I agree. I think that they intended to embrace an individual right. Whatever they may have intended, by 1868, when the 14th Amendment was ratified, it was clear from the language surrounding the debates that the framers of the 14th Amendment understood the right to keep and bear arms in individual self-defense terms, because one of the reasons that they felt the amendment needed drafting was that African Americans, the newly freed enslaved, were being victimized by uh, people who wanted to disarm them, either officially or the officials in the southern states were certainly willing to stand by and do nothing.
Yeah. And I think this sort of jumps us forward to this period in American history, which is thought of as being a second founding of the country, right? So moving from the founding era to the second founding in Reconstruction, and you all dwell quite a bit on that, and it seems again in your analysis, which I find convincing, presents good evidence for an individual rights interpretation of this right as opposed to a militia only. Um, and I don't know whether one of you could succinctly talk about the Cruikshank case, because I think that was a something that comes out of this period, an early Supreme Court decision, not necessarily thought of immediately as a Second Amendment case, but it seems fairly significant in the finding.
It's Cruikshank, I think, is critical, and uh, it introduces a fascinating historical fact. Um, the first party to bring a Second Amendment claim before the court is the federal government. Basically, you had the passage of the Enforcement Act of 1870, which allowed the federal government and the newly minted Justice Department that is developed after the Civil War to bring civil rights cases against groups like the Ku Klux Klan, which are terrorizing the newly freed Black population in immediately after the Civil War. Uh, Crookshank, we have a group of Black men who are going to the polls to vote in Louisiana. They are set upon by a huge mob, a racist mob that essentially massacres a number of them. The federal government brings criminal charges on the bases that the mob had violated the First Amendment rights of the Black men and the Second Amendment rights, the right to peaceably assemble, to go to the polls to vote, the right to bear arms because they're carrying arms for self-defense in case of just this kind of eventuality. The Supreme Court, uh, in what I think is an infamous decision, I mean, we could do an interesting sidebar right here about the first civil rights revolution. And many of the things we associate with the civil rights movement of the 1960s are really achieved to an amazing extent in the 1860s and 70s, at least on paper, only to be thwarted by the Supreme Court. And this is one example of it. The Enforcement Act gives the Justice Department the ability to prosecute people who violate civil rights. And what the Supreme Court basically says is that civil rights, in this case, First and Second Amendment rights, are that these are private individuals who are violating these rights, not the federal government. Therefore, the Congress and the federal government has no ability to protect these rights against private deprivation. To the extent that a person believes that his rights are being violated, he needs to look to state authorities, not to federal authorities. This, by the way, essentially clears the deck for racial violence to essentially drive Black people off the voting rolls in much of the South. The court is essentially saying, if you feel your rights are being violated, you have to go to state and local authorities. But in a situation where the state and local authorities are in effect in league with groups like the Ku Klux Klan, that's a right with no remedy whatsoever. But that ruling essentially clears the way for the Ku Klux Klan and similar groups to use racial intimidation to drive Black voters off the voting rolls. And in fact, something that's not really restored until after the Second World War.
Yeah. Well, there's certainly a lot of ground from there to the three major decisions of Heller, McDonald, and Bruin, and obviously the 14th Amendment becomes crucial in McDonald. But I don't want to jump all the way to the end of the story just yet. But recognizing that there's a lot of ground to cover in the 20th century, I wonder if Brannon, is there some event or a court case covering maybe the period after Reconstruction, but before Heller, that is maybe less appreciated, but very significant in terms of understanding the development of this right?
Yeah, the Second Amendment was, prior to Heller, was discussed only once in a case called United States versus Miller, which was decided in 1939. And it's a curious case. It was almost certainly a test case of the 1934 Firearms Act, which was really the first major piece of gun control legislation enacted the federal government. It was mainly intended to uh, combat gangster weapons, machine guns, sawed-off shotguns, and the like. And it was, interestingly enough, passed under Congress's taxing power because it was uncertain whether the Commerce Clause could have sustained that. It was brought against two guys who were bank robbers, Miller and Layton, and a judge with this improbable name of Hartsill Reagan in the Western District of Arkansas quashed the indictment in a very brief opinion that said it violated the Second Amendment. Judge Reagan was a supporter of gun control, so that's why it was sort of seen as a test case. Miller and Layton sort of, disappear. I mean, their indictment was quashed, so they run off. Um, the government appeals, and under the rules at the time, if a district judge had ruled that a federal law was unconstitutional, you could take a direct appeal to the U.S. Supreme Court. Didn't have to go through the courts of appeal. The court hears it without the benefit of the other side argument. The government filed a brief. The government was the only party to oral argument. The opinion is assigned to James McReynolds, who doesn't necessarily get very high marks for legal acuity, or he was also just a terrible person. And it's just basically what he says is that the opinion says, well, we can't take judicial notice of the fact that a sawed-off shotgun like that possessed by Miller and Layton would be useful to a militia. Now, in adopting that this type of arm wouldn't be necessarily useful, he basically ignored the government's other arguments that it applied to militias only and was not a right that applied to individuals. In addition, some other evidence that Miller actually, at least implicitly, endorsed the individual rights reading is that the court was developing its doctrine of standing. That is, that you have to suffer a particular type of injury in order for the court to hear your case. And if they really thought that it just applied to the militia, the court could have said, well, these guys weren't a member of any state militia, either actual or notional, and dismissed the case without even reaching the merits. But, because it was so sort of Delphic, when the Second Amendment debate got going in the 80s and the 90s, I mean, it was almost people poured over the Miller case with sort of almost, Talmudic attention, trying to parse its meaning. And so that was basically it until Heller. Incidentally, the lower courts, beginning in the 1940s, basically almost willfully misread Miller, excuse me, and would just say, well, Miller stands for the proposition that the Second Amendment does not protect an individual right, which is not at all what the decision says. And yet court after court in the 40s, in the 60s, after the passage of the 68 Gun Rights Act, into the 70s and 80s and 90s, just completely repeated this uncritically, in some ways leaving clues that that sort of made clear that the court writing the opinion had never read Miller at all. They were just repeating what other courts had sort of said it said.
Interesting.
Another difficulty with Miller is Miller was decided in 1939, and if you take it as I think makes sense, for the proposition that weapons which are useful for the militia have constitutional protection, the weapons that they were familiar with in 1939, the standard rifle of the U.S. Army was the 1903 Springfield, which was a 5-shot bolt-action rifle. Uh, and it would have been fairly uncontroversial to have said that or a similar type of rifle had constitutional protection. But if you fast forward just very shortly, actually into the Second World War, the automatic rifle, the submachine gun, as well as, of course, you know, more advanced weapons, became the weapon of individual soldiers. So there's a question: could you possibly interpret the Second Amendment to mean the protection of the belt-fed machine gun, the automatic rifle, the submachine gun, the flamethrower, et cetera, et cetera? Miller didn't deal with that because that wasn't the issue in front of the court.
Yeah.
Yes, there must be a military. It must be useful for militia service, perhaps, but is there an outer limit to that? And the court, of course, wasn't asked to address that.
Yeah. The Brandon, your point about the misreading, whether willful or not, of these previous court cases reminds me of something that Bob said when we were at the Delaware firearms law seminar. I think it was in the question and answer period where you were talking about just the availability through online media of accessing the texts of court cases and decisions and all of this stuff, and how that actually, in your view, became consequential for the way some of this jurisprudence went forward.
Well, less the jurisprudence, perhaps, but even more so, the journalistic commentary. That is, if you go back, let's say, to the 1970s or 1980s, you will constantly hear or see journalists saying, well, the court has always said that the Second Amendment applies to the militia only. And then they would cite Cruikshank for that. They would cite Miller for that, a case called Presser for that proposition. Um, and none of these cases actually say that. We were sort of wondering, well, how did this misconception come about? And then, we sort of recalled, well, look, if you wanted to read a Supreme Court case, let's say before 1980, you had to physically go into a law library and pull out a bound volume of the U.S. report where the case actually was. There was no possibility of sitting at your desk and hooking up via computer and getting a copy of the case. So I could imagine a journalist getting a report, usually from a gun control advocate, saying that Cruikshank stands for the proposition that only the militia can have arms, or only militia arms are protected. That reporter is not affiliated with a law school or a bar association or something of that sort. So it takes too much work to, frankly, check that out. Well, this organization seems to be reputable. They say that this case stands for that proposition. I will take their word for it because, frankly, verifying it takes too much trouble.
Yeah, really, really fascinating, and it highlights how, you're talking about the way in which social developments can affect the way people view guns or gun culture, but certainly also technology, can affect the way we understand all sorts of things. And this was I thought that was a neat story, so I appreciate you retelling that. And I'm gonna skip over Heller and McDonald, even though I know they're consequential, but I think a lot of people are, at least understand, what those decisions were. But Brannon, the chapter 9 is brewing an unanticipated epilogue. So this, I think, is maybe an interesting story about how scholars have to roll with what's happening out in the world while they're trying to wrap up projects. So why is this? In what way is this unanticipated, and what's the significance that you find?
Well, it was unanticipated. Bob and I had the book done, and then on April 26th, what was it, 2021, And I know that because it's my son. It was my son's 20th birthday, and I was at the beach with him. And I remember looking at the news and seeing that the court had granted cert in Bruin. And so then Bob and I agreed that it made no sense to send the manuscript along until Bruin was released. So that delayed us. We felt like we had to add that epilogue. Bruin is fascinating because for several reasons. I mean, number one, there had been built up between Heller and McDonald, so 2008, 2010, the Supreme Court sort of retired into the clouds and allowed, over 1,000 cases to percolate, in the lower courts, and granted cert on none of them. So the courts had all sort of coalesced around a certain analytical approach to this, and I don't want to get too inside baseball, but a kind of standard of review that was nominally demanding, but in application didn't result in the invalidation of any of the laws that were the major laws that were challenged. Bruin, in an opinion written by Justice Thomas, says basically that the lower courts had gotten the analytical approach all wrong and prescribed a new approach, meaning that he, in one fell swoop, basically invalidated 15 years or so of jurisprudence that had developed in the lower courts, and they were going to have to start all over. And one of the mysteries to me is why Chief Justice Roberts, who was in the majority and therefore had the ability to assign the opinion, assigned it to Justice Thomas, knowing that he would get a rather maximalist opinion. And certainly Thomas said the new standard is that the state bears the burden of demonstrating that any regulation being challenged is consistent with the history and tradition of firearms regulation going back to either 1791 or 1868. That's one of the outstanding questions. And so every law that had been litigated had to be relitigated, and that process is ongoing. And we're seeing that, as I think intended, the history and tradition test is resulting in more laws being invalidated, and still the court is providing some guidance. The lower courts are a little puzzled about how exactly they're supposed to go about this, and I think the court is going to be unable to retire back into the clouds. They had to, in the Rahimi case, they had to, step back in and provide a little more guidance about how this history and tradition test is to be applied, and I think that process is going to go on for the next several years.
Well, and Bob, I know that you actually have an academic appointment in the Department of History and Sociology, as well as law at George Washington. And I, again, being an outsider, it seems obviously the substance of the decision in Bruin is significant in terms of granting the individual right to keep and bear arms, or to bear arms outside the home. But it seems that this history and tradition test may be the more consequential part of the decision. What do you think? As a historian, you might have some particular insight into that.
Well, I think it's going to be consequential, but it's going to be consequential in a peculiar or funny sort of way, which is, I think the real question is not, and I think this was, in fact, Justice Thomas's language, not to go out and find a historical twin as such. What were they doing in 1791, or what sort of regulations existed in 1791? That's a part of it. But I think the harder part is going to be how, in terms of reasoning by analogy, are we going to be able to use history? Let me give you an example how I would approach it if I were a justice. Okay. let's take the assault weapons issue. Uh, Semi-automatic rifles with fairly large capacity, standard capacity magazines. Um, how might we use history or tradition for that? Uh, One way might be to see, well, were there any large capacity magazines, muskets in the late 18th century? Um, I think that might be the wrong approach. Yes, you might find something like that, but I don't think that's really what Bruin might be calling for. The question I would ask if I were looking at that is, uh, given uh, okay, what you might want to ask in terms of looking at that is, um, to what extent were there prohibitions on commonly available uh, types of rifles and muskets that were usable for both personal defense and common defense, either in assistance to the militia or to police forces. That might be a better way of framing the question than rather could we find some kind of physical analog to the AR-15 in 1791. I think the way to approach it is, how can we use that to do what lawyers traditionally do, which is to develop analogical reasoning with respect to certain issues or certain kinds of facts. And I think that might be a way of using Bruin and using the history uh, that Bruin says that we should employ in our decision making.
Hmm. Brandon, would you add anything to that?
Yeah, I mean, I think Bob's right. The key is uh, developing analogs and how loose or how closely do those analogs have to rhyme. And in the Rahimi case, that was a case involving a federal statute that prohibits possession of firearms by people subject to a domestic violence restraining order. The Fifth Circuit said that that was unconstitutional. Everybody expected the court to reverse, which it did in an 8-1 decision. And Justice Roberts, sort of said, well, there were surety laws that required you to put up a bond if you were a threat to somebody, and then there were these going armed to terrify the populace, and you know those together, those work. Those are sufficient. The temporary disarmament of somebody subject to a restraining order is not violative of the Second Amendment. And I've got an article coming out where I say that, well, not only does the court seem to say that you just have to find an analog that sort of rhymes, that it'll even tolerate an approximate rhyme.
Okay. Well, in the interest of time, I want to jump forward to the I guess anticipated epilogue, and I don't know whether you wrote this epilogue in the original, or whether this came to you after you wrote the unanticipated epilogue. But you say something that I think is really counterintuitive. I think very interesting to me, and so I'll just read us the section of interest, and I'll have you guys elaborate your thinking here. So I'm on page 291 for those who are reading along at home. You say, a firm indication by the courts that they will read the Constitution as protecting firearms ownership for a broad range of legal purposes, including self defense and lawful participation in defense of one's community, and that reading is shared by jurists across the ideological spectrum, may very well be the best friend the cause of gun control could have. So the idea that a robust defense of the individual right to keep and bear arms could actually be beneficial to the gun control movement. This, I think, is safe to say is a counterintuitive assertion. So uh, I'd like your thoughts on that.
Well, I think one thing that we have to do in terms of looking at that is to draw a distinction between gun control and gun prohibition. And the difficulty that we have is, I would argue, that the movement we have had since the 1960s has essentially been a gun prohibition movement. That is, the basic thrust of it is essentially the Weberian notion. The state should have a monopoly of arms, the monopoly of the use of legitimate force. Self-defense is somehow morally and philosophically wrong. The defense of the individual belongs to the state, and certainly the defense of the community belongs to the state. It's the very antithesis of the thinking that brought about the Second Amendment. So you have a movement that says we want to ban as much as we can ban. And their tactic has been, over the last 50 years, to present the public with a series of bad guns that had to be banned. So in the 1960s, the nation was told, we have to ban bolt action military surplus rifles, because that was the type of rifle that killed John Kennedy. In the 70s, we were told handguns had to be banned, or perhaps not handguns, but just Saturday night specials. Then we've been told the so-called assault rifle or assault weapon has to be banned. Every decade or so, we're told about a new type of weapon that has to be banned. And we really look at it, the amount of crime, overwhelmingly, these are not used by criminals and used in crime. They're used by ordinary citizens for legitimate purposes. Now, imagine a different history over the last 50 years, let's say. If the gun control movement had started off and said, we recognize, one, there's a constitutional right to have arms. We are not trying to subvert that right. What we really want are enhanced screening methods, so we can make sure, to the extent that we can, that people who have criminal backgrounds, backgrounds of mental instability, and other issues, that we manage to screen those people out from the gun buying process. We would have had a very different debate over gun control, as opposed to gun control as the nose in the camel's tent for gun prohibition. And we might not agree on which measures make sense or do not make sense. Do waiting periods make sense? Does licensing make sense? We could have a robust debate on it, but based on empirical facts. Do those contribute to a diminution or a decrease in gun violence? We can't really have that debate, because we have a gun control movement, or what is called a gun control movement, who makes it very clear we want any prohibitions we can get, and we are going to use any measures we get as a first step on the road to, or a step on the road to prohibition. A signal by the court, by conservative justices, liberal justices, all across the judicial and ideological spectrum, that yes, the Constitution protects the right to bear arms, and we're not going to allow that to be subverted. We got to have a very different debate over gun control measures. Think of the First Amendment. We know the courts will vindicate our right to assembly, our right to protest, our right to parade. So we don't have debates over parade permits, because we know there can't be a slippery slope, that a requirement for parade permits will morph into a general restriction on the right to assembly. If we're clear, and if we see over time that the court says the Second Amendment is real and it's here to stay, then we can have a very different atmosphere and a very different debate over whether X measure or Y measure will or will not decrease crime and violence.
Yeah. And this, the notion, one of my frustrations in the gun debates is, that everything is posed as an either or type of situation. So I appreciated, that you do talk about the possibility of serving the two public goals of increasing public safety while also protecting the right to keep and bear arms. And that's the kind of both and thinking that I wish we had more of, and this idea of having that robust defense, allowing us to enter into that conversation without fear, I think is pretty profound. But also, and maybe I'll let Brandon address this. It sounds like you're not in a kind of maximalist, shall not be infringed kind of camp, but maybe a little more Scalia like, yes, it's a right, but no right is unlimited. Is that how you see yourself?
Yeah, I mean, I think that I don't have any particular problem with the ban on civilian possession of machine guns, for example, fully automatic weapons. And I think that Bob's right that uh, the our discussion about what types of controls are effective was sort of stunted uh, because of a lack of trust between those who support gun rights and those who would like to see more limits on guns. And the analogy that I always draw is to the abortion debate. Um, there are a lot of interesting parallels that abortion supporters would vehemently oppose even bans on late term abortions because they just simply didn't trust that was where opponents of abortion would stop, because often abortion opponents were maximalists who wanted to see all abortions prohibited with few if or no exceptions. And I think that debate could have proceeded differently had uh, supporters of gun control conceded that yes, there is an individual right. It's a law-abiding citizen should be able to privately own guns. But let's talk about this. I think another avenue or another way that this debate could have proceeded is if more people were appreciative of the fact that 2/3, roughly, of all gun deaths are suicide. And that a conversation about how do we reduce gun suicides, are there measures that we can take to reduce gun suicides, would be a way to bring, I think, both sides together and begin to build some trust that one would hope could extend to
Mm,
uh, debates about how to reduce gun homicides.
yeah. And I do think that that is happening some, maybe not as much as we might like to see. So it's very really interesting to think about this potential alternative history that could have unfolded if things would have happened differently earlier on. Um, well, we're getting close to an hour. I've shaped these questions really around things that are largely of interest to me, which may not be the things that are most of interest to you. So maybe just in a final comment from each of you, if there is some aspect of the work that I've neglected to ask about, or that you think is worthy of highlighting as a parting message.
Well, I can't take credit for the historical chapters. That was all Bob. It's a wonderful social history, and it's really a story that doesn't often get told. I think that a lot of the academic literature on the Second Amendment is, again, it's sort of a kind of Talmudic parsing of 18th century texts. And I think that what our book does is to uh, zoom back a little bit and offer some historical perspective that, uh, to my mind, is lacking in most. I think the closest that comes is my friend Adam Winkler's book, Gunfight,
Mhm.
which we sort of, I think, extend. Adam's book ends with Heller, and we sort of carry the story forward a little bit. But uh, that's the contribution that I think that we make is that we, you know, sort of zoom out and offer this perspective. And my very talented co-author was entirely responsible for that.
Thank you. I'm not quite sure what I have to add beyond that.
I don't think you need to add anything. I will say that I wasn't able to read the whole book, not because it wasn't very readable, but just out of time constraints. But it is a very readable book, and I do like Adam Winkler's presentation. Also, this definitely not just in the contemporary period. I think also in the historical material does add to his book. And it does, you know, it does gets into the details of these highly significant cases like Cruikshank and Miller, but it's very readable by someone who has zero legal training like myself. So I'd encourage people who are interested in the history, interested in a different way of thinking about it. And I really think, again, the title says a lot in terms of that idea of entrusting the people to be armed, which definitely is part of American exceptionalism in, you know, the contemporary world as it was at Madison's time. So I thank you both for taking some time to chat with me about this. I've learned a lot. I know anybody who watches this conversation will learn a lot as well. So thanks so much, and good luck with your work going forward.
Well, thank you, David. Thank you very much.